Welcome to the Acheson Group webinar, Importing Food, Expect to be Expected. I am Lisa Lupo and Director of Communications for TAG, so I will be your host today. But let's start with some basic housekeeping. All participant microphones have been muted and chat is not available, but we do want to address your questions. So at any time, you can type in your questions to the Q&A section that is at the bottom of your screen. We will then address all these at the end of the presentation. So first thing I'd like to do today is introduce our presenters. So the first is Eric Edmunds. As Director of Food Safety with TAG, Eric brings a combination of legal, regulatory, and food industry experience. Eric earned a BS in biology from Westminster College in Salt Lake City, Utah, where he conducted research with the Great Salt Lake Institute in Environmental Genetics. Eric later earned a Juris Doctor degree from Willamette University College of Law in Salem, Oregon. Before joining TAG, Eric operated at Eric Edmunds Law, where his practice focused on providing comprehensive legal counsel for food businesses. Our other presenter today is Christopher Snabes. Christopher is Director of Food Safety with TAG. He has over 19 years experience in the food industry, specializing in food microbiology and food safety. Christopher received his BS in professional microbiology and an MS in biology from Eastern Michigan University, and his certified food scientist credential in 2013. He has published both domestic and international abstracts, papers, and has co-authored a book chapter in various fields of microbiology. He has presented his work at scientific meetings. Christopher is also a lead instructor for TAG's FSVP course. So in today's webinar, we will be discussing food import regulation, including food imports, of which 15% of the food that is consumed in the United States is imported from over 200 countries and territories around the world. We will be discussing the FSMA rules for importers, which include the Foreign Supplier Verification Programs, FSVP, and the Voluntary Qualified Importer Program, VQIP. FSVP was effective in January 2016, so it's been quite a while, but is still the primary cause of 483s. So to get us started, I will turn it over to Eric.
Thanks, Lisa. So today we really just want to cover principles of the Foreign Supplier Verification Program and generally FSMA. As we all know, FSMA was kind of a breaking moment in food safety in the United States. It was designed to entirely revamp the food safety system, and as many in the States realize, the preventive controls rules for human and animal food, produce safety rules, they really up the ante in terms of programs and how you're going to be managing hazards and risks in the food you're producing or in general selling to consumers within the United States. And so the key principle of FSVP that we want to focus on is the idea of how FDA is going to maintain oversight of foreign suppliers. As Lisa mentioned, there's a huge percentage of food, and that percentage is increasing year to year of the food that's actually imported to the United States. And FDA doesn't necessarily have the same capacity or ability to really maintain oversight over all these facilities. So what they've done with the creation of the FSVP program is basically create a way to enforce the food safety requirements of all these foods through the US-based actors or participants in the industry. So it really does create, the foreign supplier is still gonna likely be responsible for controlling hazards in some cases, but it's going to be the responsibility of the person importing the food in the United States to verify that the foreign supplier is in fact controlling those hazards, and if they're not, trying to make sure there's a way that those will be controlled downstream. So in general, the FSVP requirements are similar to all other FDA rules, and they're based on the overall risk and what you're really looking at, and FDA has great resources for this, first starting, what type of food is it? What type of hazards are involved with the food? And how is the supplier performing? So this not only includes their specific programs to control hazards, but also their longstanding performance. Have they ever been subject to import alerts? Have food they produced been subject to recalls? And what the FDA is looking for largely is just to make sure that hazards are appropriately identified and that somewhere along the supply chain, those hazards are being controlled and mitigated so as to protect the US consumer. So there is a lot of flexibility in their requirements. So there's not a standardized format, although we've seen that, I mean, FDA does like to see things a certain way, and we've got some knowledge on what they like to see and what they'll find acceptable. But in general, if you're meeting the underlying premise, hazards being identified and controls being implemented to mitigate those hazards and risks, then you are in a good place overall. The rest could end up being essentially technicalities and documentation practices that FDA has preferences on how you may look into that. We won't get into a ton of detail about the different flexibility in this as we're providing a general overview and some key notes, but just something to keep in mind. We can move to the next slide. So, as I said, flexibility is pretty integral to almost any FDA regulation, and they don't want to be too prescriptive. So in general, in FSVP, all records and documentation that demonstrate compliance with the requirements. So pretty broad-based. It really depends on the specific food and the supplier on how you are assessing the risk and maintaining records for what you will have, but there's a lot of leniency or flexibility, I guess would be a better word for that, in how you're doing it, because essentially, depending on the food, you may have different regulatory requirements. The differentiation between a processed food being a kind of a preventive controls requirement versus produce being produce rule. You're going to have different records and documentation depending on the food. And then you get into all the other nuances of potential risks with, is it an allergen risk or microbial risk? And I mean, generally it just follows the same standards as the preventive control rule, where you need to be considering biological, physical, and chemical hazards. Chemical including radiological and economically motivated adulteration there when it could have a food safety impact. And move to the next. Okay, so who's impacted? As I mentioned, there is a slight difference because you could fall into really two categories. And the FSVP really applies to people or importers that are importing a finished food product. So both the Foreign Supplier Verification Program and the Preventive Controls Rule have supply chain requirements. And if you're, let's say, importing an ingredient that you're going to be further processing within your establishment, there's a chance that FSVP is not really going to apply to you because you would be subject to the Preventive Controls Rule. And within that, you'd be needing to comply with the preventive controls supply chain requirements, which are essentially the same thing as the FSVP requirements. So if you're a processor in the United States and you're already complying with those preventive control supply chain requirements, you're essentially deemed to be in compliance with the FSVP requirements. So it's really designed as a way to maintain oversight over those people who are importing food and not really doing anything else to it. So it's already in a package, and anything they're doing would be kind of a de minimis action. Just to maintain better oversight over the entire supply chain, regardless of the country of origin. But The FDA has adopted a slightly different definition of importer as to what some people may be accustomed to. The Customs and Border Protection Agency has an importer of record definition that is slightly different than the FDA definition for FSVP purposes. So the importer is the U.S. owner or consignee of an article of food that is being offered for import into the United States. And so the key here, the U.S. owner and consignee needs to be physically located within the United States and taking responsibility for their FSVP requirements. So there are some nuance there in the middle. Designate an agent or representative to carry out FSVP responsibilities. You may find times when there may not be a true owner of the product when it's being imported or when it's being offered for import. And so there may be an assigned agent that's going to be responsible for FSVP importer requirements. What you're looking at there is kind of unique. And FDA has established an additional program that essentially means you can't just assign someone, or someone doesn't automatically become the agent or representative solely because you're sending it to them. They actually have to be aware of their responsibilities. So the company that's shipping or owning the food would need to get some sort of written agreement with that agent before it actually transfers. But there must be someone physically located in the United States, so FDA has better oversight and a way of having someone to contact to actually do an evaluation of the Foreign Supplier Verification Program, or FSVP, requirements. Next slide, please. So we wanted to touch really quickly on the VQIP program. It's one that doesn't get a whole lot of attention within the entire FSMA paradigm, but it is something that could be a very valuable tool for some companies. So essentially what it is, well, you sign up and pay a fee to the FDA to get expedited review of any product you're importing. So essentially, you go to the front of the line. If you're part of the VQIP program, then first, FDA is less likely to stop your food in commerce while it's entering the United States and do sampling exercises, because they have a pretty high level of confidence in your foreign supplier verification program and that you've already assessed the hazards and guaranteed that they're being controlled. And in the event that you're importing some food that may be deemed higher risk from time to time, an example I can think of from the last year, at least, with the salmonella outbreak with onions imported from Mexico, there wasn't a true import alert, but that may kind of bring that food up to a higher level of scrutiny where it's more likely to be stopped at the border for verification. That's where you really jump to the head of the line. If you're dealing in a product category that there's issues, not only do you get to kind of work with FDA and say, this is coming in at this time, but you go to the front of the line so there's minimal delay in the import of your food. Kind of if lab testing is involved, which can be take a little time and delay the whole commerce process, you get to skip the front of the line. So it really just means less opportunity for business disruption for you. So as of now, there's very few companies that actually have applied and been accepted to the VQIP program. And there's some of the bigger ones out there. But if you're thinking about it, the first thing you have to look at is your personal background history of compliance. If you've been subject to enforcement actions by FDA or something like that, you're likely not going to be able to qualify. But not only that, every single one of your suppliers has to have essentially an impeccable record when it comes to food safety. And then on top of that, you have to have a audit performed by a third-party certification body at that actual foreign facility. That's kind of a unique process that we're all familiar with third-party audits, and we all deal with them on a regular basis. for customer approval or anything like that. But this is actually a FDA approved audit body to operate in foreign jurisdictions. So these certified food safety audits do not occur within the United States, and that's something that was written into the statute of FSMA. So FDA doesn't really have any authority there to change that, but it's really an opportunity to help FDA get some oversight over the people who are conducting third-party audits at foreign facilities to ensure they're kind of qualified to perform that audit and aware of the specific requirements of FSMA to ensure that the foreign supplier is handling that. So there's a number of third-party certification bodies and accredited agencies that are able to perform those, and FDA keeps kind of a Rolodex of those certification bodies on their website if you are interested in looking into it for one of your foreign suppliers. One other aspect that is really important to FSVP in particular, and may ring a bell from those who are subject to the preventive controls rule, the FSVP qualified individual. So uses the same terms as the preventive controls qualified individual for the most part, but they are different things. So in general, the FSVP qualified individual has this kind of generalized requirement: education, training, or experience necessary to perform the activities required. When you're getting into this, you may say, I've been working in the industry for 20 years and I've been kind of doing this. That may get you there, but FSPCA does offer an actual certified course that makes it very clear that you're a qualified individual. And with some of the clients we've been working with, this is one of the first requests that the FDA has is, how do you demonstrate that you are a qualified individual? If you don't want to leave things up to chance and subjectivity of the FDA assessor or inspector, it's really easy to go ahead and take this course and get a certificate. Then you just have to show one piece of paper and it's essentially done. So we, as Lisa mentioned, Christopher is TAG's in-house lead instructor for this, and we regularly offer courses to get the certification. So it's typically our recommendation to go ahead and get the certificate. It's minimal cost and only a couple days time, but it eliminates any uncertainty on the subjectivity of your education, training, or experience that may be called into question during an FDA investigation into an FSVP program. The other aspect within the qualified individual that we have here is the ability to read and understand the language of the foreign supplier. So a foreign supplier may have a HACCP plan or a food safety plan that's written in Spanish or Italian or Polish. And I mean, there's obviously lots of languages out there, but within your documentation, you have to have someone who can actually read the language. So it doesn't need to be translated into English at this time, as long as you have someone capable of interpreting the information in a foreign language. The one caveat that we do want to point out there is that since FSVP is typically done inspection-wise with kind of just a document request, there's not necessarily someone coming on site. They just have the FSVP manager's contact information. They send an email and say, I'd like all your FSVP information for these items that we know you import. At that point, you would be required to translate those into English for the FDA to review. So it makes it a lot easier if you have a easy template that you may have filled out in English, utilizing the information provided in a foreign language. And FDA won't necessarily request all the information you reviewed if you have it well documented that you have reviewed this information and this is what you've identified in terms of hazards and how they're being controlled and conducting the regular reviews. We can jump to the next one now. So, do the FSVP requirements apply to me? Like I said, there is a slight differentiation between the facilities subject to the preventive controls rule versus those who are not. and solely importing kind of finished goods. So that's something to keep in mind. But in general, any food that's destined or meant to be consumed by humans or animals within the United States that's being imported in finished form is going to be subject to FSVP unless exempt. So always the interesting caveat in there. But we've listed a few of the exempted foods, and I'll give a little more detail on them before passing off to Chris to kind of cover some of more of the intricate details of complying with the FSVP. But low acid canned foods, there's this differentiation that different foods within the USA have different regulatory requirements. So low acid canned food is a long-standing food safety mechanism and plan for verifying the safety of those foods. And they're, for the most part, still covered by FSVP, but since the focus of the low acid canned food regulations in the United States are focused on microbial hazards, you're not required to assess the microbial hazards if the low acid canned food has been produced according to the USA requirements for low acid canned food. However, you are required to do a full FSVP for any chemical or physical hazards that may exist. And chemical, as I said before, does include radiological hazards. The list of exempted foods is quite a bit longer. But really the one that I want to focus on here is, because it's still under the FDA jurisdiction, is HACCP regulated foods like juice or seafood. You can't really take the approach that's saying, oh, just because it's juice or seafood, I'm good to go. You still have to verify that that company is in compliance with the juice or seafood HACCP regulations. But it is a bit more straightforward than some of these smaller ones. Personal use, R&D, transshipped goods, or exported and returned without processing have kind of different characterizations. So the first three, really looking at it, the food's not going to go into commerce regardless. It's either being used for research or just consumed in someone's home. Those are not going to be subject to the rules automatically. It's really kind of the personal consumption use doesn't apply to industry. It's for those ordering online foods from foreign countries. And then exported, then returned without processing really falls into this category. If it was produced in the United States according to US requirements and the prevention controls within FSE or FDA registered facility, it's not really a foreign food. So that's why the foreign food supplier verification program is not going to apply. One other thing that we'd like to throw in, not necessarily exempt, but a little bit different. The FDA does set up equivalency agreements with certain countries, depending after they do an assessment of that country's food safety controls. And while those are still required to have an FSVP, it's a little more straightforward in the sense that you're really just looking at, is this company or facility in good standing with the regulatory officials in their jurisdiction. So those include Canada, Australia, and New Zealand. But outside of that, anywhere else in the world, you're already going to be looking into a full FSVP application and requirement in the event of an inspection. So with that, I wanted to pass the time over to Chris, and he'll go over some of the more detailed requirements.
Thank you, Eric, and thank you, Lisa. Great to be here, everybody. Thanks for joining us. So let's go over some of the basic requirements of an FSVP. What is it? What does it consist of? What do I have to do? First, as with a similar food safety plan, as everybody should be familiar with, you have to conduct a hazard analysis. And hazard analysis is the core of the FSVP. You need to make sure you include the severity and likelihood of the risk if it's there. So the more robust your hazard analysis is, the more complete your FSVP will be. Then you want to conduct an evaluation of the foreign supplier's food safety performance and the risk posed by the food. And part of this would be, you would ask yourself, how's that company doing? What are they doing? What are they producing? How are they producing it? How have they done in the past? And things you might want to check is, have they ever had any recall? A lot of companies on their supplier approval program say, have you ever had a recall in the last couple of years? When you're doing your FSVP, you want to look at the entire history. You should look at, see if they had any recalls. And if they did, what did they do about it? You know, what kind of corrective actions they put in place? Other things you could check, you know, have they ever received a 483? Are they on the import alert list, for example? Are they on the red list? If they were on it and they got off, what was their corrective action? What did they do? The next thing you want to do is, okay, based on my evaluation, am I going to approve them or disapprove them? You have to document. Did you approve them, yes or no? If you do move forward with approving a foreign supplier as importer, you must also establish a written procedure to ensure that the food is imported only from approved suppliers. Typically, this is a separate SOP that a company has in place, and it documents just exactly what types of paperwork, audits, processes have to be in place before they can approve that supplier. And that all becomes part of the FSVP paperwork in general. That generalized SOP is part of the FSVP. From there, you need to determine, okay, now how am I going to verify this? Am I going to go on-site every year? Am I going to do an on-site once and then depend on, say, a GFSI audit? What are you going to do? Tell me what you're going to do and how you're going to do it. There are times when you have to reevaluate the foreign supplier. And at a minimum, the rule is pretty clear. It says a minimum once every 3 years. But definitely, whenever there's a reason to do so. For example, if they got stopped at the border, customs stopped them for a reason, or they're in a recall, or their existing approval from, say, a GFSI entity has ceased, or it's time for renewal. It might be time to take another look at your FSVP to make sure they're controlling the hazards that they say they can control. Finally, it's necessary to identify yourself at entry. Most importantly, keeping records and all associated documentation has to be for at least 2 years. You got to keep the documentation for 2 years. Another thing that a lot of companies that we've worked with in the past who got into issues was that they were importing food without having an FSVP in place. Technically, you must have the FSVP completed before any food that you're importing has been imported. So you got to get all your ducks in a row, so to speak, and have all your paperwork done in place ahead of time. Next slide, please. Recently, there was an update on the FSVP importer data entry. Part of this was removing what they used to say, the UNK symbol. That meant unknown. And that was placed there when this rule first went into effect, because at the time, companies weren't exactly sure what category they would fall under. So they allowed you to use the category UNK for unknown. Well, starting in July of this year, that is no longer allowed. You will have to use an existing 3-letter designation as to what type of importer you are. And that's FSV, which means you're under FDA regulation, FSX, which means you're exempt. Eric gave you some examples, some exemptions. Or RNE, which means it's for research and development purposes. As you're importing, one thing you should realize is you have to have a DUNS number. Now, a DUNS number is a free number. Anybody can apply for it and stays with you forever as that entity who's the importer. The DUNS number is what we like to call a unique facility identifier. And that UFI number is the DUNS number. So let's put in the paperwork when you are identifying yourself at the time of entry. Next slide, please. So let's get to some interesting data. What you see on your screen here are the top 5 reasons why 483s were issued for non-compliance in fiscal year 2021. Right at the top, first thing we see, there was no FSVP completed. Then we see a lot of repeatable issues that we see for a lot of importers that have more than one reason why they got the 483. There was no hazard analysis that was done, or the hazard analysis is incomplete, or you didn't base your evaluation on risk, or you didn't have any documentation to prove that you approved that supplier. If you're dependent on an audit, where's a copy of that audit? Has it been translated into English for review? Another thing we see is, as it's up here, is the fifth one there was no written procedure for using an approved supplier. That's something I alluded to in an earlier slide. It's what we call the standard operating procedure, the written SOP. You have to have a document that shows how do you approve your supplier? What do you do? And that becomes part of the FSVP. In 2021, fiscal year 2021, 1,666 importer FSVPs were assessed. Now, when you look at those numbers versus how many 43s are put out, that means about half to 65% of everybody who was inspected received a 43 for one or more reason. Typically, it's for more than one reason. Of that, 58 warning letters were issued, 54 were due to remote inspections. Now, that's something that's unique with this rule compared to other FSMA rules. Is in order for the FDA to assess you, they have the ability to do it completely remote. They don't have to come to your office. They don't have to come to your facility. They can simply send you an email, telephone call, or a letter and say, we would like to see an FSVP for X product or your entire FSVP program. So it's always important to make sure you have your FSVPs in place before you import any food. Next slide. Thank you. What are some other reasons that we've seen for 43 being related? Well, you didn't maintain or file FSVP. You didn't provide adequate assurance that the foreign supplier is producing food for public health protection. I'll give you an example. Eric talked about the low acid canned food rule. If they're producing low acid canned food, you have to see some kind of documentation if they're following that rule. Okay, if they don't have that rule approved for that facility, then they're not following it as adequately enough. Other things, it wasn't translated in English. It wasn't signed or dated. You know, that one always kills me. It's the simplest thing to do. Don't forget the QI has to sign and date the FSVP. You didn't retain FSVP as another one. The FDA might have requested a copy of it electronically, and you didn't provide it to them through their electronic portal in a timely manner. One other thing I want to, and Eric mentioned this, was translating documents into English. It's always best if you could possibly have your documents translated in English before you approve them. If not, if you can understand that language, great. Then ask for a translation. The reason being is when the FDA asks you for copies of your documentation, they expect it to be in English, as Eric said. If you don't have an English, they're going to give you what they call reasonable time to translate in English. And you can have a discussion with the FDA officers exactly what is reasonable time. It's not defined. If it's only 1 or 2 pages, they might expect it the next day. If it's a complete audit that's 55 pages long, they might say, well, get it done in 2 weeks or 3 weeks. Have that discussion, ask what their expectation is, but it's not written in stone. So it's always best, if at all possible, to have it translated in advance. Next slide, please. So what's on tap for fiscal year 2022? Well, what we have learned is, looking back at 2021 and having a discussion, we've realized what the FDA has said that they're going to do for 2022. In 2021, about 1,600 human food facilities were inspected, and only 60 animal foods were inspected for FSVP. Almost all these were done remotely. For 2022, the agencies projected the following: 580 human food FSVPs were inspected for the very first time. They've never been inspected before. They never looked at the program. They're going to get that call for the first time. 75 animal food FSVPs are going to be inspected for the first time. And the agency has noted that they're going to concentrate on pet treats and finished foods only for the animal FSVPs for this fiscal year. Another thing that they're doing, which they haven't done very much at all, is they're now going to take a look at those who import dietary supplements. They're going to pick 50 organizations that import dietary supplements. Dietary supplements have a unique quirk with this rule. I'm not going to get into details, but they also have to have an FSVP. The majority of inspections are re-inspections. That means if you were inspected within the past, the FDA expects you to, number one, maintain your FSVP. If they found anything that was amiss, maybe you received a 483, maybe you received just a friendly, hey, heads up, make sure you correct this before we come back next time, they're coming back. So over 1,300 people or entities are going to be re-inspected for FSVPs, okay? Again, most of these are going to be done remotely. The inspection process can be done simply by a telephone call. Typically, it's followed up with an email, and typically the email will have a secured, encrypted electronic portal for you to send the information to the FDA. Next slide, please. So, probably asking yourself, I have an FSVP. I think it's okay. How do I make sure it's okay? How do I can avoid getting a 483? Well, there's some simple steps. First of all, you should have a properly trained and documented qualified individual. FSVP QI is the one's got to sign off on the documents. That's the entity that the FDA is going to reach out to when it's time for them to review your FSVP. Another aspect that you have to really make sure is you have an FSVP for each article of food you import from each supplier's location. And that's important to know. A lot of companies import from a supplier that might have, say, 5 factories in Europe, and they might import the same product from all 5. Great. Since they're all 5 different locations, I now need 5 different FSVPs. On the other hand, let's say you import 5 similar products from a single factory. And the only difference is maybe it's the color. Well, that can be grouped into a single FSVP. If it's similar hazards, similar supplier, similar item, you can group them. But the key is it must be from the entity that produces that. We've seen with some of our clients where a company says, yes, I supply X product for you, and they might be located, say, they're located in France, but actually they use a co-manufacturer that's located in Italy. Great. I need to approve the Italian manufacturer because that is where the food's coming from, not the French company that's taking care of it, having co-manufactured by the Italian site. So that's an important thing to realize. It has to be where it's actually being produced. Other things, do your basic homework. Has there been a recall? Have they received a 483? Are they on the import alert list? Is the hazard analysis complete? Okay, again, we can't overemphasize how important it is to have a robust, complete hazard analysis. To help you with your hazard analysis, the FDA has actually published their Appendix 1. The Appendix 1 is very important when you do your hazard analysis for FSVP. We have seen clients who have done a hazard analysis and have not put down all the hazards that are listed in Appendix 1, and they have actually received a 483 for that. How can you avoid that? Well, you can simply go ahead and look at that Appendix 1, see what the hazard is for the food you import, list it in your hazard analysis, and now describe. Is it a hazard? Why or why not? That's something you have to detail. That way you've shown that you've actually considered the hazard that the FDA has already recognized. So at a minimum, you really need to make sure you follow Appendix 1 when you do your hazard analysis. Other things to remember to help avoid a 483 is make sure you have the records in English. If they aren't and you are asked to convert them into English, make sure you do it within that reasonable time frame after you've had that discussion with the investigator. And with that, Lisa, I believe we're ready for some questions.
Okay, thank you very much, Eric and Kristen. A lot of information there, and we do have a number of questions from the audience. The first one is kind of a two-part. It came in separately, but I'll put them together. So it says we have contacted for an we have been contacted for an FSVP inspection by the FDA and found out that suppliers are listing us as the FSVP importer without our consent. The other half of the thing says, I also want to add that we have disputed that we are listed as FSVP importer with the FDA, but they don't seem to care. So the questions are, do you have any advice on how to navigate this? They work for a retailer in the US. Also, is there any regulatory action that can be taken against suppliers that are not obtaining written consent before listing a non-aware entity as the FSVP importer?
That's a long question. Do you want to tackle that first?
Yeah, I can start off and then you can add in, Chris. So I think, and this is my initial impression, we'd be more than happy to discuss some more details with you offline. But so feel free to reach out if you ask this question. But what I feel is likely happening here, in my portion, I mentioned the FSVP importer is the owner or consignee of the product when it's offered for sale or offered for import into the United States. And only if an owner or consignee doesn't exist is where you get into the agent category. And so the retail facility, and this is where I'm curious about more details. If you've already paid for the goods or have an arrangement to pay for the goods upon arrival, anything like that, you're in that owner or consignee category. And there's not really a way to get out of it. So if I'm misunderstanding the details a little bit there, we're happy to discuss to see what avenues you have to navigate the situation. But I have a feeling that that's why the FDA is not being very responsive to your questions and thoughts on being made the FSVP importer.
Yeah, and I'll add on just a little bit on that. This is an example where you want to talk to each party needs to talk to each other and have typically what we suggest a signed agreement. Who will be the actual FSVP for that article of food that's being imported? That way it removes the ambiguity and it allows you to definitely say, I am the FSVP for this. With retailers, I believe you said you're part of a retailer. That's something we see kind of frequently where the retailer says, I am not the importer, I'm buying it from somebody else who is the importer, and here's my written agreement. Or you might say, yes, I'm the retailer, however, I'm going to handle the FSVP paperwork for whatever reason. It's good to sit down and have a two-way agreement and have a written agreement as to who's going to be the FSVP importer for each and every type of article of food being imported.
Okay, thank you. Next question. You mentioned, Eric, in your presentation, you mentioned importing an ingredient for further processing at your facility and how FSVP and PCs apply. What about a distributor who imports ingredients and then sells them to end users who further process? We are the importer of record and meet the FSVP importer definition as well.
Yeah, so in that situation, see this a little clear. Typically, the person who's importing the food is going to have to require going to need to comply with the FSVP requirements. And then if they're selling it further downstream to a person who's going to further process it, that person's just within the PC control and doing general supply chain controls. But it's really that importer is going to be considered the FSVP importer in this case, unless they've contractually assigned those responsibilities to someone further down the supply chain.
Okay. Is it public record if a company has a VQIP?
I can answer that, and yes, currently there's 4 in existence.
So just to add, publicly available, FDA on their website even lists them. So right now, the people who have been approved are Costco, Pacific Seafood, and then a couple of importing companies that aren't as well known in, I guess, by name, Palmex and Sylvina. But that's essentially an application period that, well, for now, you have till the end of the month to finish your application to be part of the VQIP program for 2023. Yeah, so that's kind of a short window at the beginning of each year. And those are the 4 that FDA announces publicly when they've been accepted into the program.
Okay. Is a GFSI audit a qualified audit for the VQIP program?
I'll take that one since it's VQIP as well. Not necessarily. This is going to be a lawyerly answer. It depends. Generally, so GFSI is kind of an industry standard for third-party audits, but to be in the VQIP program, you have to have someone who's an FDA accredited, there's an accredited auditor who is accredited by one of the FDA certification bodies. So that's kind of a separate process. So while those people who have achieved the FDA certification body or accredited auditor standards may also be a GFSI auditor, they're not necessarily the same thing. So really this accredited auditor certified body is an additional standard that requires application fees and qualification review by the FDA.
Okay.
It could be both, but yeah, not straightforward.
Okay. So if ingredients are being imported into the US for further processing, do the FSVP requirements apply?
I'll start on, or go ahead, Chris.
I was going to say, so the answer kind of depends on a couple things. So could you repeat that again? If they're importing and then doing what? What they said they're doing?
If they're importing into the US for further processing, do the FSVP requirements apply?
Okay. There are some exemptions for grains, but in general, if I am importing it and I'm doing nothing to it, I'm importing the raw ingredient, whatever it is, and then I'm selling it to somebody else. As the importer, I need an FSVP. If you're a manufacturer and you're importing something and you're going to further process it, then that falls underneath your supply chain program. And typically, that's usually what we see. In the rule, we say the preventive controls rule for human food or animal food, or the produce rule, would apply for that manufacturer as they're importing food. They want to make sure they're importing that item that's produced safely. And then they're going to do further processing. So they're going to follow their existing human food plan or their animal food plan or the produce rule. And that's typically how that's conducted. And so a FSMA was written so you don't have to have both a supply chain program and FSVP for importing. And typically the FSVP program is for those products in general that you're not going to do anything to. You're just importing it and you're selling it. It's called de minimis handling, shall we say.
Okay. The next question.
I think the thing to look at here is the idea that we kind of said all foods require an FSVP unless exempt. So start with that as the standard. And then as Chris mentioned, if you are subject to the preventive controls rule and in compliance with the preventive control supply chain requirements, then you're deemed to be in compliance with the FSVP because they're essentially the same requirements. So yeah, FSVP is required, but if you're already complying with supply chain requirements within the preventive controls rule, then you don't have to have a separate program that's duplicative.
Right.
Okay, so I was just going to say the next question was very similar, just talking about one slide said any and one slide didn't. So you've answered that question as well with that. So would FSVP regulations apply for Canadian facilities for US-based companies?
And I can answer that one. And the answer is yes. So there are some requirements. Now, Canada is one of the 3 countries that Eric mentioned that is exempt. And if I'm going to be importing goods from Canada, is what we call a modified FSVP. First, you have to make sure it's within the scope of recognitions agreement to 3 countries and make sure it falls underneath that safe food that's in the agreement. You have to make sure that they're under the regulatory oversight and they're in good standing. Okay, so they don't have any warning letters from that country. If so, you don't have to do a hazard analysis, which is kind of nice because that's a lot of work. And you don't have to conduct a foreign supplier evaluation for approval and verification, but there is stuff you do got to do. You must monitor whether the foreign supplier remains in good compliance with the Food Safety Authority, whatever country or entity that they're under. If there's an issue, you have to take prompt corrective action of anything associated with the hazard. Make sure that when you're importing it hasn't been not taken care of. You have to still ensure you keep all your records, so you still take care of that, and you still have to identify yourself under the Customs Board Protection of Time Entry that you are the FSVP importer. So you still got to do stuff. You still have to do some paperwork, but it's not as involved and it's not as intricate. And typically, it's easier to write an FSVP if you're in the U.S. importing stuff from Canada, New Zealand, or Australia.
Okay. Can the foreign supplier perform the hazard analysis?
And I can take a shot at that one. The answer simply is yes, they can do the hazard analysis, but you as the qualified individual, and this is where your training on a qualified individual really comes to the key, you have to say, okay, my foreign supplier did a hazard analysis, I'm reviewing it, it looks like it's complete, or it looks like they didn't address, say, allergen cross contact or something like that. You can review it, and if everything looks good to you, you can use their hazard analysis to fill out your FSVP, sign it, date it, and if there's anything that's not addressed, and again, I refer to Appendix 1, then you need to take that extra step. Say, how are they controlling these other hazards that they haven't identified? Are they not controlling them at all? If so, that might be a reason to reject them. If they are controlling it and they have a different, say, document that shows it, get a copy of that, review it, so you can make sure all hazards are properly identified. But yeah, if a foreign supplier does their own hazard analysis, the QI needs to review it, make sure it's acceptable, sign it, and date it.
Okay, thank you.
Falls into the category of trust but verify.
Exactly.
Use the documentation, but make sure it's correct.
Okay. Can you describe how the fees for VQIP are established?
Yeah, I can handle this one. I won't get into a ton of details, but every year when the FDA releases the fee schedule for VQIP, they kind of explain it. Essentially what it is they assess how much time and how much money is the FDA going to have to spend to review your application and oversee the accreditation body. And they basically cover their costs. So for this year, the cost is basically set at $16,000 is the application fee. That's what the FDA thinks it'll cost them to review your application and either approve or deny.
Okay. Can the FSVP QI be hired as an external person of my company, or should it be someone that works every day on my company?
So I can answer that one. You have an option. The rule is very clear. They do not have to be an employee of the company. I will say it sure as heck does help though, only because whoever is writing and maintaining the FSVP has to maintain that information. And again, you got to keep those records for X amount of years. But technically, a third party or a consultant can write your FSVP. If you want to come in an agreement where they're your qualified individual, they could sign off on your behalf. You could do that as well, and they can handle that paperwork. But yeah, technically they don't have to be an employee, but it most certainly does help. And another example would be is if your company imports, say, thousands of goods. We have clients that's what they do. They import thousands of goods. It's more than it's a highly recommendation. You have somebody internal doing that. That's just a lot of paperwork to keep track of, and a lot of dates you have to keep in mind. When are things expiring? When's an audit expiring? When do I have to re-review this? I have to check, databases all the time for 2,000 suppliers to make sure they haven't got it on a red list, they haven't had a recall. It's a lot of work. And typically, if you're using a third party or consultant to do that, that's typically not that cost effective, to be honest with you. But yeah, you absolutely can use a third party.
Okay. If the HACCP review checklist states that all documents are reviewed, does that count as an FSVP document, or does it need to call out FSVP approval?
Well, that's a good question. So if I understand the question right, so if, let's say they had a summary list of all the documents that they looked at, and they wrote down the name of the document, they reviewed it, signed and dated, they reviewed all of them, does that count? The list of documents that they have on that summary somehow must be in a separate SOP. It's high. In order for me to approve a foreign supplier for FSVP program, these are the types of documents that I will expect to receive, and I will maintain copies of them. So it has to be a little bit more written out like that. Typically, when the FDA comes to take a look at your program, or the request to look at your program through email, for example, they're going to want to see more than just that checklist. They are actually going to want to see those documents, and they'll request to see those documents. So be prepared and be expected to provide those documents. Just relying on a simple checklist, yep, I have a copy of all the different documents, and supplying that to the FDA, I wouldn't rely on that, because they're more than likely going to ask to see all the documents associated with that FSVP. We worked with many clients who received 483s, and that's exactly what the FDA has wanted to see. They want to see a copy of a GFSI audit. They want to see a copy of the regulatory agency that approved them in the foreign country. If it was a foreign country audit, they want to see the foreign country audit. If they're in the low-acid canned food rule, they want to see the documentation that shows have an official low-acid canned food program in place. So the checklist is nice, but I would say don't rely on it. Make sure you have all those documents to back it up if you say you check them off, that you actually have a copy in hand.
Okay, we're getting very close to time here, so we'll take one more question and then wrap it up. So participant says, I purchased imported product from a US-based broker. Is it their responsibility or mine?
I can answer that question. This is where you have to have that discussion. The two of you have got to sit down and say, which one of us is going to be the FSVP importer? We both qualify. One of us has to take care of the documentation. Who's it going to be? Is it going to be the broker, or is it going to be you? And do that before you import the food. If you've already imported the food and you don't know, it's never too late to talk to your broker right now. As soon as this webinar is done, give them a call. Say, who's taking care of that paperwork? Is it me or you?
Okay. Well, we'd like to thank you all for attending our webinar today. And as a thank you, we will be sending out a link to get your own infographic on how to avoid a 483 for your FSVP, based on all the information you learned today, but kind of a quick summary of how you can see how to avoid it. And feel free, this webinar will be posted on our YouTube site, and feel free to visit the site for other webinars and videos. And thank you again for your participation.
Thank you, everybody. Have a good day.
Thanks, everyone.